Start. This court time and again has examined the scope of jurisdiction of the High Court under Section 482 CRPC and laid down several principles which govern the exercise of jurisdiction of the High Court under Section 482 CRPC. Stop. A three-judge bench of this court in state of Karnataka held that the High Court is entitled to quash a proceeding if it comes to the conclusion that allowing the proceeding to continue would be an abuse of the process of the court, or that the ends of justice require that the proceeding ought to be quashed. Stop. In para 7 of the judgment, the following has been stated with the remarks that in the exercise of this wholesome power, the High Court is entitled to quash a proceeding if it comes to the conclusion that allowing the proceeding to continue would be an abuse of the process of the court, or that the ends of justice require that the proceedings ought to be quashed. Stop para. The saving of the High Court's inherent powers, both in civil and criminal matters, is designed to achieve a salutary public purpose, which is that a court proceeding ought not to be permitted to degenerate into a weapon of harassment or persecution. Stop. In a criminal case, the veiled object behind a lame prosecution, the very nature of the material on which the structure of the prosecution rests, and the like, would justify the High Court in questioning the proceedings in the interest of justice. Stop. The ends of justice are higher than the ends of mere law, though justice has got to be administered according to laws made by the legislature. Stop. The compelling necessity for making these observations is that without a proper realization of the object and purpose of the provision which seeks to save the inherent powers of the High Court to do justice between the state and its subjects, it would be impossible to appreciate the width and contours of that salient jurisdiction. Stop. The judgment of this court in state of Haryana versus Bhajan Lal has elaborately considered the scope and ambit of section 482 CRPC. Stop. Although in the above case this court was considering the power of the High Court to quash the entire criminal proceeding including the FIR, the case arose out of an FIR registered under sections 161, 165 IPC and section 5 of the Prevention of Corruption Act 1947. Stop para. This court elaborately considered the scope of section 482 CRPC, Article 226 of the Constitution, in the context of quashing the proceedings in criminal investigation. Stop. After noticing various earlier pronouncements of this court enumerated certain categories of cases by way of illustration where power under section 482 CRPC can be exercised to prevent abuse of the process of the court or secure the ends of justice. Stop. Para 102, which enumerates 7 categories of cases where power can be exercised under section 482 CRPC, is extracted as follows. Stop. In the backdrop of the interpretation of the various relevant provisions of the code under Chapter 10 and of the principles of law enunciated by this court in a series of decisions relating to the exercise of the extraordinary power under section 226 or the inherent powers under section 482 of the code, which we have extracted and reproduced above. We give the following categories of cases by way of illustration wherein such powers could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice, though it may not be possible to lay down any precise, clearly defined, and sufficiently generalized and inflexible guidance or rigid formula. Stop.